Okay, so in this video, we're going to be talking about the likelihood of confusion element of a trademark infringement action. So in our last class, we talked about the initial elements of a trademark infringement claim, namely the requirement to show a valid trademark and to show ownership of that valid trademark, which kind of conflated in a lot of ways. And we'll return to those questions later in the class. But suffice it to say, the key point there is that the trademark owner, the person bringing the trademark infringement action, has to show that the mark that they're using in commerce is actually distinctive. In other words, it actually communicates or should be expected to communicate information about the source of product or consumer product or service to consumers. But that's not enough, right? You can't just show that you own a valid trademark. You also have to show that the defendant using the allegedly junior mark to your senior mark is actually infringing. And in order to make that showing, you have to show a likelihood of consumer confusion. And that's not just the likelihood of consumer confusion in relationship to the actual mark in question. It's a likelihood of consumer confusion in relation to how the mark is actually being used, right? So it's a contextual analysis, not just an analysis that looks only at the mark itself. Right, so I asked you to look at the casebook includes the Top Tobacco v. North Atlantic case involving two different companies producing roll your own tobacco, right? On the left, you see a can of Top Tobacco, Top being a brand that's been in the roll your own tobacco market for over a century, and Zigzag, familiar for their cigarette papers. And at that point in time, it only recently gotten into the roll your own tobacco market as well. In other words, they were well known for selling papers. They were trying to get into the roll your own tobacco market, and presumably Top, which had dominated that roll your own tobacco market for a long time, was none too thrilled about seeing a well-known competitor entering the same market as themselves. And of course, Top had a long-standing registered trademark in the logo that you see, the word Top over an image of a red, white, and blue spinning top, but also over the word mark Top itself. So it wasn't just the logo they were claiming, it was the use of the word Top in relation to tobacco products. And Zigzag came onto the market with their own tobacco product. And when they revamped their packaging materials, they added the phrase fresh Top TM canister on the front of the packaging, in order to indicate to consumers, presumably, how the product was being packaged. And Top brought an infringement action against Zigzag, arguing, look, we have a registered trademark on the use of the word Top in relation to tobacco products. You're using the word Top in relation to tobacco products, ergo you are infringing. You're using the registered word mark that we own. It's no question that we're the owners of a trademark in the use of the word Top in relation to tobacco. You're using it on your packaging, QED, we win, you lose, and we should be able to prevail. And their claims are roundly rejected. Now, why is that? Is there any question that Zigzag is using the word Top? None whatsoever, right? You can see right there on the canister, there's no question Zigzag is using the word Top. The question is how they're using it. And the court says, look, you can't just point to the use of the word mark itself. It's how the word mark is used in context, and consumers know how to read packaging, right? Consumers know how to derive information from products, and they know when a word is being used as a mark and when it's not. And here, you're using the word Top in a way that clearly indicates that Top is the name of your brand of tobacco. It is indicating consumers where the tobacco in question is coming from. Zigzag is not using the word Top in that way. It's very clear that they're selling Zigzag tobacco and not Top tobacco. And they're using fresh Top canister in a way that consumers clearly will not use to derive the source of the product. Therefore, you just can't prevail on a consumer confusion claim, because there's no way that this actual use could actually be confusing to actual consumers. Now, I know that Zigzag is using a TM mark in relation to the phrase or the word mark fresh top. So that means that they're claiming that fresh top has the potential to function as a mark, even though they haven't registered it, right? TM means essentially unregistered trademark. I would have a circle R if it were registered. So they're claiming that it has the term fresh top has the potential to convey meaning to consumers, to convey information to consumers, to be distinctive. Distinctive in what way, right? And is that kind of distinctiveness a problem in relation to what top is claiming? The court seems to think not. Why not? And is the court correct? Okay, well, let's also then talk a little bit about the benefits and the process of obtaining trademark registration. So what's the purpose of registering a trademark? Well, we all know that you can get a trademark just by using a distinctive mark in commerce. What's the point in registering then? Like what benefits come along with it? It's expensive, it's time consuming, and involves interacting with the government. Those are all a drag. So why are you going to do it? Well, it provides a lot of benefits to the registrant. Right. So if you register a trademark, that provides you a lot of benefits if you choose to litigate. Right. So for one thing, you get prima facie evidence that the trademark in question is valid. Why is that? Because it's been evaluated by the Trademark Office, and the Trademark Office has signed off on the validity. Courts are going to take that with a considerable amount of deference to the Trademark Office. Likewise, that's prima facie evidence that you own the trademark. In other words, not only has the Trademark Office reviewed the mark for validity, but they've also indicated that you're the owner of the mark in question. So it gives you a leg up in the litigation process, puts you in a stronger position. Moreover, it provides nationwide notice that you're making a claim to the use of that particular mark. And that can be really beneficial because, if you're using a mark locally and, somebody else is entering into a similar market in a very different part of the country, they might not necessarily be aware of your use of the mark in question. But if you can point to the register, then, that shows that that was an easy one-stop shop place for them to look, and anyone can use the register for free just by going to the Trademark Office website and going to test the trademark search service. So it provides you a lot of protection against claims that weren't aware of it, and helps preclude the likelihood of other people using the same mark in a similar context. It also provides some additional defenses against, the importation of counterfeit goods, right? So the Customs Office will be looking out for goods that are marked improperly, and certain defenses against state law dilution claims as well, right? Concerns that somebody might bring under a state law. It's not a strong issue, but it's still there nonetheless, that your mark is close enough to be diluting theirs. So, you can show the Trademark Office didn't think that was a problem, therefore state law shouldn't think that's a problem either. And then finally, it does also provide the possibility of obtaining what's known as an incontestable mark. So after a particular period of time, a trademark registrant is able to apply for incontestable status, and that provides additional defenses with respect to the validity of the mark in question. Now, it isn't actually incontestable. It can still be legally contested, especially if, for example, the mark were to become generic, right? If genericide were to happen, then an incontestable mark might still become a generic and unprotectable mark. But incontestability is another kind of double strong protection of the distinctiveness and validity of the mark in question that can be obtained only after a particular period of registration. Okay, so what do you do in order to register a mark? Well, you file your application with the PTO and it gets examined. And once the PTO makes a determination, it's either going to go get published for opposition, or if it's rejected, you can have a back and forth with the PTO all the way up through the federal courts as to the registrability of the mark in question. Once the mark is deemed registrable, right, either by the trademark office or through litigation, it'll get published for opposition, which means the trademark office will alert the world that you filed this registration application and that they're moving forward with it. And then third parties will be able to come in with objections to that registration. Typically, if they think that the mark you want to register is too close to a mark that they're already using and likely to be confused with it, and they can then bring in evidence that your mark shouldn't be registered because it's actually likely to cause confusion rather than a distinctive and therefore valid mark. Once the determination has been made that it won't be confusing, then a certificate of registration will issue, and after a particular period of time, 6 years or so, it's possible to apply for incontestable status for the mark in question. That'll be a 10-year registration period. There is a requirement to file proof after a particular period of time, 5 to 6 years, that the mark is actually still being used and retains distinctiveness, largely an administrative process, but nonetheless important. And subsequently, the mark can stay registered potentially forever, right? As long as the mark is being used in commerce and maintains distinctiveness to consumers, that mark's still valid, and the mark can persist until it stops communicating information to consumers in the relevant way. Okay, so what about limitations on registration of a mark? And mind you, there's a difference between registration and validity, right? So you can only register certain kinds of marks, but even an unregistered mark, even an unregisterable mark might still be a valid mark if it's communicating information to consumers. Registration is a ministerial role on the part of the government, and therefore at least somewhat discretionary with limitations. One of those limitations being the First Amendment, which will come up in just a second, especially in relation to Section 102 of the Lanham Act, right? So what happens there? It says, look, certain kinds of marks were statutorily excluded from registration. The most relevant ones for the conversation we'll be having is immoral, deceptive, scandalous, and disparaging marks. The idea being we don't want the government to be recognizing the validity of cuss words and slurs and that kinds of thing, those kinds of things as valid. Trademarks now, the meaning of those terms has changed significantly over time. And ironically, some things that were not recognized as slurs many years ago, or at least not treated as slurs, are well understood to be slurs today. So, questions about the kind of historical application of these limitations, but certain kinds of marks were excluded from registration, some for prudential or discretionary reasons, and others for functional reasons, right? So you'll see marks that are deceptively misdescriptive. In other words, if you're trying to mislead consumers, you can't register. Well, it's like we want marks to be conveying information, but also information that is truthful to consumers about source. And a mark that's intended to deceive them would not be a valid mark, and therefore would be a non-registrable because it's not doing what a mark should. Likewise, a mark that's merely descriptive is, by definition, not conveying information about source to consumers. It's just describing the product in question. Therefore, it also should not be distinctive, because if it's merely descriptive, then it's not distinctive and therefore shouldn't be a mark in the first place, right? Okay. So the problem came in when the Trademark Office refused to register certain kinds of marks that it saw as being satisfying the first category here. So in particular, the disparaging category. So Asian American kind of dance punk band called the Slants attempted to register the name of the band with the Trademark Office, and it was rejected on the ground that it was disparaging to Asian Americans. And as you can imagine, the band members were quite surprised. I mean, they all themselves were Asian American, and they saw this as being a way of reclaiming this term that had been used as a slur and kind of making it their own and kind of running with it in the space. And they litigated all the way up to the Supreme Court and ultimately prevailed, with a majority of the court finding that the limitation on disparaging marks violated the First Amendment. Now, there have been a long history of the Trademark Office refusing to register marks that were scandalous and immoral. And the writing was really on the wall for those as well. And lo and behold, shortly afterward, case came before the Supreme Court, Iancu v. Brunetti. Iancu was the head of the USPTO at the time. Brunetti was the owner of the brand FUCT, which according to Brunetti stood for Friends You Can't Trust. This was used widely on various products, but the Trademark Office refused to register on the ground that it was a notoriously vulgar four-letter word, represented a notoriously vulgar four-letter word. And unsurprisingly, the Supreme Court held that no, this is also a First Amendment violation. The Trademark Office can't discriminate in the registration process against marks that it finds to be vulgar or demeaning in that respect. So four-letter cuss words are also registrable marks. So now it's kind of opened up a whole nother question as to, is there any room, is there any First Amendment room for limitations on the registrability of particular kind of marks? Open question, we'll talk about it in class, and I'll share with you some additional resources you can check out as well.